Welcome to the webinar. My name is Amanda Washton, and I'm a partner in the Thompson Hine Labor and Employment Practice in the Los Angeles office. I'm delighted to introduce my colleague and co-presenter today, Managing Associate Brittany Mallow, joining us from our Cleveland, Ohio office. Today's webinar is the second of two sessions covering employment laws and the distinct challenges California employers face on hiring, wage and hour requirements, and employee protection. These areas can vary significantly from state to state and even federal requirements. Today's presentation will focus more specifically on leave requirements, wage and hour rules, meal breaks, expense reimbursements, and addressing PAGA claims and compliance. Before we begin, a few housekeeping items. Today's program is being recorded, and we will send a link to all attendees, including the PowerPoint, within 48 hours of today's presentation. If you have any questions during the webinar, feel free to use the question box located in the control panel on the upper right side of your screen. We will answer as many of the questions we can at the end of the webinar. Thank you for your interest, and now we will begin. Just a quick overview of the agenda for today. Brittany will discuss the leave laws. I'm going to talk about wage and hour requirements and the differences between California and federal laws, and the Labor Code Private Attorneys General Act of 2004 and PAGA claims. Take it away, Brittany. Thank you.
Thanks, Amanda. Good afternoon, everyone. So first, as Amanda said, I'm going to give an overview of California leave laws, and we'll spend some time comparing those leave laws with FMLA and whether or not those leave laws run concurrently or consecutively. Anytime you hear me say the word concurrently, it means they run at the same time. If I say consecutively, it means the leave runs one after the other. So first, let's start with just a general overview of FMLA leave. So this applies to employers with 50 or more employees within a 75-mile radius. Also, the employees must have worked for the employer for 12 months with at least 1,250 hours during those prior 12 months. And FMLA provides for 12 weeks of unpaid leave for qualifying reasons. Moving on to the California Family Rights Act, which we'll refer to as CFRA. This, like the FMLA, requires that employees work for at least 12 months or 1,250 hours in those prior 12 months. Different from the FMLA, though, is this applies to employers with 5 or more employees in the state, and also different from the FMLA, there is no 75-mile radius requirement. It's just 5 employees in the entire state. Similar to the FMLA, though, it does provide for the 12 weeks of unpaid leave. This leave runs concurrently or at the same time as FMLA leave. Eligible employees can take CFRA leave for several reasons. The first of which is the birth, adoption, or foster placement of their child. Note here that this does not cover pregnancy, and we'll get into that further in a little bit. Also provides leave for caring for the following people with a serious health condition. So this is a spouse, registered domestic partner, child, parent, grandparent, grandchild, sibling, or a designated person. It also provides leave for employees' own serious health condition or a qualifying exigency related to an active duty of the employee's family member in the military.
Brittany, just to pipe in there, in California, we get a lot of questions for the designated person under the California Family Rights Act. Employers should note that an employer can't restrict who an employee chooses as their designated person under the CFRA, but they can limit an employee to one designated person for a 12-month period of time.
Thanks, Amanda. All right, a couple key differences between the FMLA and CFRA, other than the few I already pointed out. So first, the pregnancy is a serious health condition. So under the FMLA, pregnancy is covered as a serious health condition. However, under the CFRA, pregnancy itself is not covered as a serious health condition. Instead, in California, a pregnant employee is entitled to pregnancy disability leave, which provides up to 4 months of leave. And we'll get into the details of pregnancy disability leave in a little bit, but just note that pregnancy itself is not covered as a serious health condition under the CFRA. Another difference is that under the CFRA, registered domestic partners are equal to spouses, and this is not the case under the FMLA. Third noted difference is this care for ill or injured service members, often referred to as military caregiver leave. Under the FMLA, not only do employees get 12 weeks, but they actually get 26 weeks of leave if it's an employee who is a spouse, child, parent, or next of kin of a covered service member. They may take the 26 weeks, which is equal to about 6.5 months of leave during a 12-month period to care for a covered service member who was ill or injured in the line of active duty. And this is different from the CFRA, which does not provide for this this military caregiver leave. Next, pregnancy disability leave, or referred to as PDL. This covers employers with 5 or more employees as well, and employees are eligible for this leave upon hire. Under PDL, you're entitled to 4 months per pregnancy. This is not per year, so if an employee has 2 pregnancies within the same year, it would be the 4 months is calculated per pregnancy. And leave may also be taken intermittently. So to go back and kind of break down this 4-month period, the 4-month leave period is determined by the number of hours an employee would normally work within 4 calendar months. 4 calendar months is actually 17 1/3 weeks. So for example, a full-time employee who's working for 40 hours per week would be entitled to 693 hours. And that's the 40 hours a week times 17 1/3 weeks. Otherwise, the number of working days that constitutes the 4 months is calculated on a pro rata or proportional basis for employees who are working less than 40 hours a week, more than 40 hours a week, or on a variable work schedule. And another example here for especially employees on a variable work schedule, in order to calculate what 4 months of leave would look like, employers are required to take the 4 months prior to the leave and average that out to get what a normal work month would look like. Additionally, a note on the intermittent leave, employers calculating this intermittent leave can count leave increments using no greater than 1 hour. Employees are eligible for the pregnancy disability leave if they cannot, because of pregnancy, perform the essential functions of their job. They cannot perform the essential functions of their job without undue risk to the employee, to the successful completion of pregnancy, or to others. They're suffering from severe morning sickness, or they must take time off from work as a result of pregnancy, childbirth, or related conditions, which include prenatal and postnatal care, bed rest, gestational diabetes, preeclampsia, postpartum depression, loss or end of pregnancy, or recovery from childbirth. Next, we'll talk about the interaction between PDL and other leaves. So first, PDL runs concurrently or at the same time as leave taken under the FMLA. This means the FMLA does not provide any additional leave entitlement beyond the allowances provided under the PDL and CFRA for the purposes of pregnancy-related leave. However, PDL is a separate and distinct right from leave under the CFRA. So in practice, PDL is provided to a pregnant employee first, potentially before an employee has even given birth. Once an employee is no longer considered disabled by pregnancy, childbirth, or the related medical condition, an eligible employee could then take up to 12 work weeks of what's called baby bonding leave under the CFRA. If applicable, the FMLA would run concurrently with and get used during the employee's use of both pregnancy disability leave and the CFRA. Also note that the pregnancy disability leave only applies to the parent with a disability related to pregnancy, whereas the FMLA would also apply to the second parent in a same-sex couple or adoption or anything like that. The 2 types of leave run consecutively, so CFRA and PDL, and this equates to a total of 29 1/3 weeks, and that comes from the 17 1/3 weeks of leave under the PDL plus 12 weeks of leave under CFRA. Wanted to note also that there are additional rights under the Federal Pregnant Workers Fairness Act that we refer to as the PWFA. So federal laws are generally largely irrelevant to California employers because California law is typically so much stricter. But just wanted to note that in 2023, the PWFA came out and kind of followed the tightening of more stricter requirements for employers. The EEOC issued some PWFA regulations in April of last year, and it should be of interest to employers. It does list, for example, the regulations explain that where an accommodation due to pregnancy is obvious, such as allowing the employee to carry or keep water or food nearby, take an extra bathroom break, sit or stand as needed, take extra breaks to eat or drink, or temporarily adjust some start times due to morning sickness. The employers may not require documentation from healthcare providers. Overall, the PWFA regulations remind employers of the need to engage in the interactive process, which I'm sure you're all aware of. And to the extent that reasonable accommodations are made, they must be, unless it would be able to truly demonstrate this undue hardship. And obviously, you know, the PWFA is kind of under fire now. There's several legal challenges across the country, but as of right now, just wanted to note some of those protections and kind of obvious things that are included with that as rights for workers. Next, paid family leave. So paid family leave is part of the state disability insurance program, and it provides wage replacement benefits only. It's not job protection. This is funded by mandatory payroll deductions from covered workers. So for employers, it applies to employers that pay $100 or more in wages in a calendar quarter within the year or preceding year. And for employees, it's for employees who must have earned at least $300 from which the state disability insurance deductions were withheld. Permissible uses under PFL include caring for a seriously ill child, spouse, parent, grandparent, grandchild, sibling, domestic partner, or designated person, bonding with a minor child within 1 year of the birth or placement, or participating in a qualifying event because of a spouse's registered domestic partner's, parents, or child's military deployment to a foreign country. Under the PFL, employees may receive benefits for up to 8 weeks within any 12-month period. The 8 weeks of leave can be taken intermittently, but employees may only receive PFL benefits during the first year after a child's birth, adoption, or foster care placement. As of January 1st, 2025, so new for this year, employers can no longer require employees to take up to 2 weeks of vacation leave before they receive the PFL benefits. So as of last year, you were able to do that. Employees are still able to take weeks of vacation before receiving PFL, but employers are no longer able to require this. PFL leave runs concurrently with leave taken under both the FMLA and CFRA. All right, next, the California Paid Sick Leave Law, PSLL, and this comes from the California Healthy Workplaces, Healthy Families Act of 2014, and it applies to employers that employ at least one employee who works in California at least 30 days within a year. All right, so for the amount of leave under the PSLL, employers have a few options and they can do one of the following. The first option is to provide a front-loaded annual grant of 40 hours or 5 days of paid leave at the beginning of each year or 12-month period. And this is actually up, so this changed as of the first of the year. Previously, it was 24 hours and 3 days, but as of January 1st, it's now 40 hours and 5 days. The second option for employers is to allow employees to accrue 1 hour of paid leave for every 30 hours worked. And the third option would be to provide the sick leave that accrues on some other regular basis. Employees just must have no less than 40 hours of accrued leave by the 200th calendar day of employment or in each 12-month period. For this leave, employees can use the leave beginning on the 90th day of employment and after that as accrued. So important to note here that while employees begin accruing immediately, they are not able to use the leave until the 90th day of employment. Employers can also limit the usage of paid sick leave to 40 hours or 5 days per year, whichever is more beneficial to employees. So for example, an employee working 5 10-hour shifts per week would get 50 hours of leave instead of the 40. Some more notes for the accrual under the PSLL. So leave begins on the first day of employment, as I mentioned. Accrual may be capped at 80 hours or 10 days. And with the accrual method, the unused leave is carried over to the next year subject to that 80-hour, 10-day cap. there is no carryover required for the front-loaded annual grant. So not only is the annual grant simpler in a lot of other ways, one of the big reasons we find employers are drawn to that option is because there is no carryover. A couple other notes here. If an employee is hired within 1 year, accrued unused leave that was not paid out on termination is reinstated and may be used according to the same use and accrual provisions in the Act. However, payout is not required at termination. For permitted uses under the PSLO, it's for diagnosis, care, or treatment of an existing health condition of or preventative care for the employee, a family member, which is defined as a child, adopted, foster, biological, parent, or parent of a spouse or domestic partner, a spouse, registered domestic partner, grandparent, grandchild, sibling, and as of a new change a couple years ago, any person designated by the employee. Could also be used for a specified purpose if the employee is the victim of domestic violence, sexual assault, or stalking, and also for a reproductive loss event that is otherwise unpaid. So reproductive loss event is defined as the day or for a multiple day event, the final day of a failed adoption, failed surrogacy, miscarriage, stillbirth, or an unsuccessful assisted reproduction. Employers are able to set reasonable minimum increments of no more than 2 hours for use of paid leave under the PSLO. All right, the next type of leave is victims of qualifying acts of violence leave. And these protections are no longer housed under the Labor Code, but instead are under the California Fair Employment and Housing Act. As of January 1st, 2025, victim is now defined as an individual against whom a qualifying act of violence is committed. And this can include domestic violence, sexual assault, stalking, brandishing a weapon, making threats to cause death, or causing bodily harm. And this was changed as of January 1st. It used to be crime or abuse, and now it's qualifying act of violence, and this was intended to be more encompassing. Employees who are victims of a qualifying act of violence may take time off from work to obtain judicial relief. All employers are covered. However, in addition, employers with 25 or more employees are required to provide leave to an employee who is a victim, or if the employee's family member is a victim, to seek various forms of relief, treatment, or services. And here, family member is defined broadly to include child, parent, grandparent, child, sibling, spouse, domestic partner, or designated person. And the leave protected for employees who are victims or who have family members who are victims. For those with 25 or more employees can include things like seeking relief, injunctive relief, assisting family members to get medical attention as a result of injuries sustained from an act of violence, to assist them in seeking domestic violence program, rape crisis center services, securing new residences, or to otherwise to provide care for them in recovering from their injuries. A few more notes here. So employers may limit the total leave to 12 weeks if the employee is the victim. And for leave for employee whose family member is the victim, employers may limit that to 5 days. Employers are able to request certification, so you can request a police report, a court order, or other documentation of the treatment or services to support the leave. And this type of leave does run concurrently with any leave under the FMLA or CFRA. Next, slightly different type of leave. This is crime victim leave for judicial and other proceedings. And this is for an employee who is the victim of a covered crime or an immediate family member, a registered domestic partner, or the child of a covered crime victim's registered domestic partner may take leave to attend to judicial proceedings related to that crime. And most of these covered crimes, they involve real violent felonies, serious felonies, or felony embezzlement, including felony domestic violence, vehicular manslaughter, felony child abuse, felony stalking, kidnapping, rape. The statute here does not specify an amount of leave, however. Next, jury duty and witness leave. These are cover all California employers, and they apply to employees who are required to serve on jury duty or those who must appear in court to comply with a subpoena or court order. And there's also no specific amount of leave designated under these statutes. All right, voting leave. So this also applies to all employers. And for this type of leave, employees are entitled to take up to 2 hours of paid voting time off at the beginning or end of their regular work shift, whichever allows the most free time for voting and the least amount of time off, unless it's mutually agreed with the employer. And if the employee knows or has reason to believe that they'll need this leave, they are to provide notice of at least 2 working days ahead of time. And sometimes, this is one that kind of causes annoyance for employers because it's hard to, some of us know you stop to vote on your way to work, it takes 5 or 10 minutes. Employees do, however, have the ability to request the 2 hours. So understanding the differences of maybe what the employee requests and what's actually needed may pop up, but this is what the law requires. Organ and bone marrow donation leave. So this applies to employers with 15 or more employees, and you're required to provide an employee acting as an organ or bone marrow donor with a paid leave of absence. The employee is eligible if they have been employed for 90 days before the beginning of such leave. For the employees who actually donate the organ, they're entitled to 30 business days of paid leave and then 30 additional days of unpaid leave in a 12-month period. For those employees who donate bone marrow, they're entitled to 5 business days of paid leave in a 12-month period. Employers may require the employee to use up to 2 weeks of accrued sick time, vacation, or PTO for organ donation, or up to 5 days for bone marrow donation. This type of leave does not run concurrently with the FMLA or the CFRA. All right, next, school activities leave. All California employers with 25 or more employees at the same location must allow eligible employees with school-age children to take up to 40 hours off per year to do some of the following: find or enroll or re-enroll in school or with child care provider, participate in activities at the child's school or with the child care provider, or address a child care provider or school emergency if notice is provided. This leave can be limited to 8 hours in a calendar month, but also for the year it's 40 hours. Next, for bereavement leave, this type of leave covers all employers with 5 or more employees. The employee must be employed at least 30 days before the start of the leave. They may take the bereavement leave upon the death of the following. This is a spouse, child, parent, sibling, grandparent, grandchild, registered domestic partner, or parent-in-law. The employee may take up to 5 days of bereavement leave on the death of a family member, but the leave must be completed within 3 months of the family member's death. And with that, I'll turn it over to Amanda.
Thank you, Brittany. I know that's a lot of different types of leaves, and we'll try to answer questions. I see there's been some questions on this. We will try to get to answer your questions on these topics at the end of the presentation. And yes, you will get these slides within 48 hours of the end of the webinar. So, and we'll be happy to answer questions. But we have, in addition to a lot of different leave rights in California, we have a lot of different wage and hour requirements as well. And I wanted to go through some of the basic pitfalls that California employers deal with regularly and the differences between the FLSA or the Fair Labor Standards Act federal statute requirements for these wage and hour laws and California's. The first one is minimum wage. Under the FLSA, it's $7.25 per hour, but in California, due to the high cost of living here, we have a much higher minimum wage of $16.50 an hour. That changes on a yearly basis and goes up on a yearly basis. It started at $16.50 in January of 2025, but please take note that some counties and certain professionals have additional minimum wage requirements For example, there's a Santa Monica minimum wage. There are airport worker minimum wages that are higher than the $16.50 per hour. So it's important to keep that in mind and make sure that you have looked into where your employees are located to see if a local ordinance may apply. The next issue we see a lot in wage and hour claims is issues regarding overtime. Under the FLSA, it's employee receives 1.5 times pay or their regular rate of pay for hours over 40 in a week, and there's no daily overtime requirements under the federal statute. But in California, there's multiple ways an employee can earn overtime. They receive 1.5 times pay for hours over 8 in a day or 40 hours in a week. They receive double time for over 12 hours in a day and over 8 hours on a 7th consecutive day. I mentioned, by the way, the regular rate of pay for under those overtime requirements, and I'll get a little bit more into that when we talk about meal and rest breaks as well. Next is meal and rest breaks. Under the FLSA, there's no federal requirement for meal or rest breaks, but breaks of 20 minutes or less must be paid if they're provided. In California, however, we have an extensive meal and rest break requirement. California employees are required to receive 30 minutes of unpaid meal breaks for every 5 hours worked. It's in our labor code. They also receive 10-minute paid rest breaks for every 4 hours worked. So a standard employee who works an 8-hour day will receive a 30-minute unpaid meal break and 2 10-minute paid rest breaks that need to be spaced out within the first 4 hours of the day and the second 4 hours of the day. That trips up a lot of employers. In addition, in California, we have final pay rules. Under the FLSA, there's no specific federal requirement for the timing of their final paychecks for employees. But in California, terminated employees must be paid immediately. Resigning employees must be paid within 72 hours or immediately if they've provided 72 hours notice. That trips up a lot of employers who need to make sure that they're calculating all of the final pay correctly and paying that at the time of termination. And that includes, we'll talk about that in a little bit, that includes any vacation time as well. Which brings me to the next slide, vacation time. Under the FLSA, there's no federal requirement for vacation pay or the payout upon termination. But in California, accrued vacation is considered earned wages or vested right and must be paid out upon termination. You also cannot have a use it or lose it policy for vacation time. So meal and rest breaks, I want to talk a little bit more in depth about because it's a very common class action claim in California. Under California law, the requirements for meal and rest breaks are very specific and designed to ensure that the employees receive their adequate meal and rest breaks during their work shifts. There's duration and timing rules as well. The 30 minutes of unpaid meal break must be provided for every 5 hours worked, and it has to be in the first 5 hours of the day. If an employee works less than 6 hours total in the day, then that meal break can be waived. If an employee works more than 10 hours in a day, they're entitled to a second 30-minute meal break. That second meal period may be waived, but only if the first was not. Oftentimes, an employee will request to have their meal period or waive their meal period so they can leave early because these meal periods are unpaid. But an employer cannot agree to allow a second meal period be waived if they have not taken their first meal period. Another condition in the labor code is that these meal periods must be uninterrupted and employees must be relieved of all duties. We receive a lot of class action claims of employees who are informed or pulled back off of their lunch breaks to do work. So it's very important that supervisors are trained that once an employee is clocked out for lunch, they cannot be pulled back or interrupted. Meal and rest breaks have additional requirements. So employees are entitled to that 10-minute rest break every 4 hours worked. Again, the average employee who works an 8-hour shift will get 2 rest breaks, but they must be paid out, and rest breaks are paid. So clocking in and out for rest breaks is not done because those rest breaks are paid. employees clock out for lunch because those lunch breaks are not paid. It's important to keep track of all of these, the employees who take their meal and rest breaks, because the penalties are very significant. If an employer fails to provide a meal break, they must pay the employee 1 additional hour of pay at the employee's regular rate of compensation or regular rate of pay for each workday that the meal or rest break is not provided. Only 1 break penalty is assessed per day. So if an employee misses both their rest break and a lunch break, they'll only receive 1 break penalty. But it adds up when an employee misses a meal break, because it's per break, per employee, per pay period. And so these penalties can get very, very large. Note that these requirements are only for non-exempt employees. I mentioned the regular rate of pay. This is an issue that is commonly trips up employers, because it's not the same thing as the straight time rate. The regular rate of pay includes all compensation earned by the employee during the work week, and it's essentially an average. So a straight time rate, let's say an employee makes $10 an hour, to collect the regular rate of pay for purposes of both overtime and now also meal break penalties and rest break penalties, you have to factor in all other forms of compensation within that calculation. So for example, we see a lot of shift pay differentials. So a nighttime worker might receive an additional hour of pay for work after 8 p.m. That needs to get factored in on a per pay period basis into that regular rate of pay to calculate overtime correctly, and also now these meal period and rest break penalties. There was a recent case, the Farrah versus Lowe's Hollywood Hotel case, that decided that in 2021. So these meal period, these 1 hour extra of pay has to be calculated at the regular rate of pay. The regular rate of pay is calculated by dividing the total compensation earned in a work week by the total number of hours worked in that work week. It's essentially an average, and it must be paid and determined on a weekly basis. The next issue we see a lot in class action claims in California are reimbursable expenses. The FLSA focuses on ensuring that employees do not reduce wages below the federal minimum wage with no specific reimbursement requirements. But the California Labor Code requires employers to reimburse employees for all necessary expenditures or losses incurred in direct consequence of the discharge of their duties or in obedience to the employer's directions. These are common issues that we see in class action claims. Oftentimes, businesses overlook the small expenses, like employers may neglect to reimburse parking fees or mileage or minor office supplies. We also see a lot of cell phone claims. If employees are using their cell phones on the job and are called in to and from work, or off, back to and from their breaks using their cell phones, they will make a claim for unreimbursed cell phone expenses. Oftentimes we see misclassification of expenses. Employers might incorrectly classify certain expenses as non-reimbursable, such as home office expenses for remote workers. But if an employer is requiring, and it's part of the job description, that these remote workers are available remotely, those would be reimbursable expenses. It's also very important for employers to properly classify their workers. If an independent contractor is not entitled to the same reimbursement rights as an employee, it's very important to make sure that you're reimbursing employees' expenses and not classifying them as independent contractors. Oftentimes, misclassification claims will include claims for reimbursable expenses. The next issue we see a lot in California wage and hour claims are claims regarding California commissions. Commissions is a form of compensation paid to an employee for services rendered in the sale of the employer's property or services, and is based proportionally upon the amount or value thereof. In California, it's very important to be aware that employers must provide a written commission agreement to the employees who are paid commissions. This agreement must detail the method by which commissions are computed and paid. It's in our labor code. And that's important that employers note that upon the termination of an employment, earned commissions must be paid in accordance with the terms of that commission agreement. So it's important to define when a commission's earned or when it's calculable, because that rule that I discussed earlier, the final pay rule in California, sometimes employers who haven't separately set out the commission structure or clearly defined when commissions are earned are rushing to try to calculate how many commissions are owed to an employee at the time of termination or separation. So if it's clearly defined in the commission agreement that a commission isn't earned or calculable until a later date, then the employers aren't necessarily rushing to make sure that final pay upon termination includes commissions. So that's a lot of the wage and hour issues that I just discussed I see a lot in California class actions, but it's important to note that in addition to the wage and hour class actions that we see and the issues that we see on all of the California Labor Code requirements, we also see claims for under the Labor Code Private Attorneys General Act, or the bane of every California employee's existence, including my own, known as PAGA. PAGA provides a procedural vehicle for employees to act as private attorneys general to pursue penalties for themselves and others without satisfying the high standards of class certification. The statute doesn't create substantive rights for employees, but provides for civil penalties for labor code violations that previously did not authorize such penalties. So when it was enacted, it was really enacted to help employees try to figure out how to properly calculate the penalties for labor code violations that didn't necessarily already exist in the California Labor Code. It allows these aggrieved employees to act like a state enforcement agency or the LWDA by bringing representative actions as if they are the enforcement actors on behalf of themselves and others to recover those penalties. But they can only collect a percentage of the penalties recovered. Why is it so unique? Unlike class actions, PAGA actions, class actions must be certified, but PAGA actions do not. There's no governing standards of like class actions for the PAGA representative claims. They proceed on a representational basis and don't need to be certified. There are some procedural obligations, however. Employees must provide notice to the LWDA, or the Labor and Workforce Development Agency, and the employer of the specific statutes alleged to be violated, including the facts and theories supporting the violation. But we've seen a lot of PAGA notice that don't really delineate these facts and theories very clearly. They receive and can receive civil penalties calculated at $100 for each aggrieved employee per pay period for the initial violation and $200 for each subsequent violation. And courts have the discretion to award less. This is a maximum civil penalty, and it's considered discretionary, but it is in the statute that it's $100 for the first violation and $200 for each subsequent violation. In the past, plaintiffs' firms have basically calculated that the first violation or the first pay period is the first violation, and every single pay period thereafter calculates at a $200 penalty, but it was recently amended, and I'll go through that very shortly. There is a 1-year statute of limitations that applies to PAGA actions. That's in CCP 340, and employees who prevail can recover their attorney's fees and costs. All of the California Labor Code claims, by the way, the plaintiff attorneys or the successful attorneys can recover their attorney's fees and costs. But the civil penalties in a PAGA case are divided. 75% goes to the LWDA and 25% to the aggrieved employees. That was recently changed, which I'll go over. Some classic PAGA case examples. So I've seen a suitable seating case, and there is a statute in the California Labor Code that does provide that an employer must provide seating where suitable for the employee. A classic case came up in I don't know if there's a CVS where you're located, but a CVS case is the famous case that created the suitable seating under PAGA. The claimants there alleged that while they were standing at the registers, they should have been provided stools or seating. But these same employees that also work the registers at CVS were also opening the cases to get the client's deodorants. They were working the photo booth. And so the argument of the employers were that suitable seating isn't appropriate when these employees are moving around the location, and the job description doesn't require any stationary, they're not set stationary at the registers. But the case determined that where appropriate, if there is a spot where a stool could be provided, it should be. And that case resulted in a very large PAGA award. I also see improperly calculated bonuses as PAGA claims. Again, I talked to you about that regular rate of pay. Bonuses need to be calculated into that, or non-discretionary bonuses need to be calculated into the regular rate of pay. And I've seen cases where they'll make a PAGA claim in addition to the regular rate of pay claim under the California Labor Code. We also have seen a lot of unreimbursed COVID-19 expense PAGA cases. They are not just required to, employers are not just required to reimburse employees for those test kits, for example, but they also need to be reimbursing, or they also need to be calculating all the time spent for employees to be waiting to be tested, or temperature checks prior to clocking into work. That is a classic PAGA claim that I've seen a lot. We also see a lot of misclassified independent contractors bringing not only the wage and hour claims because of misclassification, which has its own penalties in the California Labor Code. They'll seek additional PAGA penalties for each pay period that they were not classified as an employee. Needless to say, PAGA resulted in rampant abuse by the plaintiffs' bar. Although it was originally intended to augment enforcement of California's labor laws for the benefit of workers, it resulted in the proliferation of litigation that mostly benefited plaintiffs' attorneys with large fee awards and resulted in minimal payments to the employees. According to a study by the California Business and Industrial Alliance conducted in 2021, PAGA cases that are prosecuted in court by plaintiffs' attorneys instead of those decided or brought forth by the LWA itself proved to be much more costly for employers and resulted in significantly lower payments to the employees themselves. Plaintiffs' counsel sought stacked penalties for all of those ticky-tacky wage and hour claims that we were talking about, including wage statement claims, and resulted in huge attorney's fees awards based on those claims. An employee or former employee previously could sue for violations that they personally didn't even suffer. There were also a lot of conflicting decisions regarding how to implement the statute of limitations and how to manage the kinds of claims and discovery issues involved in a PAGA claim, and made procedural arguments very difficult for the employers. And again, employees who would go to court would receive significantly less than those claims that were actually pursued by the LWDA or the enforcement agencies. This resulted in new legislation, which is a little bit of hope for employers. It applies to civil actions brought for under PAGA, or PAGA civil actions brought on or after June 19 of 2024. There's a lot of different issues that were raised in these. Originally, it was they were intending to get rid of PAGA completely, but Gavin Newsom enacted these two statutes, AB 2288 and SB 92, which essentially reformed PAGA as opposed to eliminating it. And this was a sort of compromise between the plaintiff and defense bars representing employers and employees. One of the issues that has changed now are the standing and statute of limitations. The new legislation limits the definition of an aggrieved employee and narrows the standard to assert a claim to those who were actually employed by the alleged violator and personally suffered each of the violations alleged during the period, that 1 year period prescribed in the statute of limitations in the Code of Civil Procedure. Again, previously they were able to bring claims even if they hadn't personally suffered it, but now that has been limited. Also, the new legislation allows for injunctive relief, whereas before the only remedy listed in PAGA was the penalties. The goal of this provision was to add a new remedy of injunctive relief to stop the practices as opposed to focusing only on punishment. There's also now a discretionary reduction as well as an enlargement of fees. This is intended to be a discretionary statute, but as a compromise to the plaintiff's bar, because so many of these amendments do benefit employers, they provided that the courts also have discretion to enlarge the fees as well. There is now cure definitions. It was previously the ability to cure alleged violation were limited to ticky-tacky wage statement violations themselves. So failing to put an address on a wage statement, or just a typographical error on a wage statement were the only types of violations that an employer could cure. Now there are more understandable cure definitions in the statute itself. An employer can correct a violation alleged by the aggrieved employee if they're in compliance with the underlying statute specified in the notice and the employee is made whole. What does made whole mean? Previously, it was unknown, it was left ambiguous, but now it's clarified that the employee is made whole when they receive the unpaid wages that are allegedly due under the violation. It dates back 3 years from the date of the notice, plus 7% interest, any liquidated damages required in the statute itself, as well as the attorney's fees and costs. At least there is a definition, whereas before it was undefined. But one of some of the biggest changes now are to the penalties that are assessed as part of a PAGA violation. Previously, like I said before, the subsequent violations were calculated ambiguously, and plaintiffs' attorneys always assessed a $200 penalty for any second violation. But now that secondary or the $200 increased violation only occurs if a court or the LWDA determines that there was a violation. There's also now caps to these penalties that are possible if an employer takes reasonable steps. So there's 2 scenarios now where an employer can cap PAGA penalties by showing they've taken all reasonable steps to comply with the law. Before receiving a PAGA notice, the penalties or the maximum exposure of these penalties in the notice are capped at 15% if they take reasonable steps to cure or change or make the employees whole, or take reasonable steps to make sure that they're in compliance with the labor code violations alleged in the notice. After receiving a PAGA notice, there's a 60-day deadline to respond and take reasonable steps. And in those circumstances, an employee can cap the penalties at 30%. What are reasonable steps? It includes, but aren't limited to, conducting periodic payroll audits and taking action in response to the results of an audit, disseminating lawful written policies, training supervisors on applicable labor code and wage order compliance, and taking appropriate corrective action with regard to supervisors. So whether the employer's conduct was reasonable is evaluated by the totality of the circumstances and considers the size and resources available to the employer, as well as the nature, severity, and duration of the alleged violation. But it is possible to take the reasonable steps to prevent these types of claims. In addition, their derivative penalties have now been eliminated. The PAGA reform permits courts to reduce the stacked penalties that used to take place for violations arising from the same payroll policy error, for failure to pay timely wages upon separation, failure to timely pay wages during employment, and wage statement violations. So if there was an error, for example, on that regular rate of pay issue, that could have resulted previously in stacked penalties for all of those different violations. If it was calculated incorrectly on a wage statement, it was also calculated incorrectly at the time of the final pay. It was also calculated incorrectly on every single pay period. So now the PAGA statute prevents those penalties from being stacked or added on a multiple basis for essentially one violation. And finally, the pay periods have been changed. It used to be that employers who paid their employees on a weekly basis as opposed to a bi-weekly basis would result in larger penalty awards, but the new legislation now provides for a reduction by 1/2 if an employee's regular pay period is weekly as opposed to bi-weekly. There's also finally a change in the penalty split. It used to be 75% to the LWDA, 25% to the employees. Now the employees receive slightly more. They receive 35% instead of 25%, and 65% goes to the LWDA. Finally, there's new procedural mechanisms for managing these PAGA claims. The court can limit the evidence or the scope of any PAGA claim to ensure an effective trial. The court can consolidate or coordinate civil actions for overlapping violations against the same employer. We often saw and still see PAGA-only actions filed in addition to class actions for the same labor code violations. And that's usually done for procedural machinations to avoid arbitration agreements or removal to federal court. So the courts now have, specifically part of the labor code, have the right to consolidate, coordinate, stay, or dismiss some of these overlapping actions. And there are also now a lot of early evaluation and resolution procedures. These the early evaluation procedure is a completely new addition and is aimed to facilitate early resolution for filed PAGA claims. So once an employee receives a actual filed complaint, they can request an early evaluation conference to stay the proceedings and attempt to try to resolve this, or even get some a court-ordered stay to go to a neutral evaluator to hopefully resolve the cases without resorting in these huge litigated matters. So these procedural mechanisms and these newer forms do provide hope for the employers to sort of limit the scope of some of these very extensive PAGA claims that we're seeing. And it remains to be seen, but again, there's new hopes, and there are now procedural mechanisms and ways to prevent some of these claims if we're taking the reasonable steps that are now provided for in the statute. So we can help try to mitigate the scope of these or the risk of these kinds of claims by helping you go through your California wage and hour requirements and making sure you're in compliance going forward. And with that, I think we're at the end, and we can try to answer any questions you might have, and can help facilitate any, go over any of these leave issues, wage and hour issues, or PAGA issues you may have going forward.
Yeah, so Amanda, a couple questions that we received. So the first was, if you are a company based in Ohio, but you have 2 full-time employees in California, if they are, and the question is, are those employees eligible for pregnancy, disability leave, and CFRA, so California Family Rights Act leave under that statute as well? The answer to that is no, because you have to have 5 employees there in order to qualify.
The location of the employees, yes.
Yes. Another one we have is related to breaks. So are meal breaks tracking for both exempt and non-exempt employees?
No, these are for non-exempt employees only.
Okay. And then we had another one which just asked to go over the California paid sick leave law again. So this is California's version of paid sick leave. And I think the high notes there are that employers have 3 options. You can front load the leave, and it's 40 hours or 5 days. Second option is they can accrue the leave 1 hour for every 30 hours worked, or you can have some other way to accrue the leave, but it has to be 40 hours by the 200th calendar day of employment or in each 12-month period. And the other second high note on that type of leave is that employees can't begin using that leave until their 90th day of employment. So even if the employer has a front-loaded policy where they would be given all 40 hours or 5 days up front, or if they're accruing 1 hour every 30 hours worked, they wouldn't be able to use the leave until the 90th day of employment.
I'm seeing a lot, thank you, Brittany. I'm seeing a lot of questions on specific types of industries. There are definitely exceptions to both the meal and rest break policies, the wage and hour laws, depending upon whether certain types of employees are exempt. So it really, there's we should go through the individual employees that you have or the types of employees that you have on an individual basis. So I'm happy to do that afterwards. I won't be able to address specific industries during this presentation. But there are some definitely certain industry or type of worker exemptions to these wage and hour laws. Can the rest break and meal break penalties be stacked? Well, they're stacked in a way that they can be, they're per worker, per pay period, but they can't be stacked more than one meal break penalty per day. So depending on how many days an employee works, they can receive a penalty. They work 5 days in a week, they can receive 5 penalties that week. And yes, it can be stacked with a PAGA penalty, but there are arguments now that those would be mitigated, or the PAGA penalties can, you can request that the not be stacked as far as an additional PAGA penalty, but they will make claims that they are stacked. Let's see. It's hard for me to read as they're coming in. I'm getting new ones. Will we have other trainings? Yes, we will provide some more trainings, and we can also help you. I am working on auditing some of our clients' wage and hour policies to comply with California, so we're happy to help you personally go through your workforce and determine which wage and hour or labor code laws are required with your workers. Does a PTO plan? Let's see. Sorry, I'm trying to read these questions as they come in. I get a new question. Will you get these slides? Yes, you can get these slides. You should get them within 48 hours. But if you have more specific questions on any of these slides, you feel free to send an email. We'll try to respond as we can.
I think that pretty much covers the high level questions we received. There's some more very specific industries or examples in here, but we can follow up with that after.
I see we're getting a lot of questions on these leaves of absences, and so yes, we will try to create more detailed seminars or webinars about the leaves of absence going forward and in the future. If there's interest in a need, we're happy to do that. Are non-exempt employees required to approve their own time card? That's interesting. That's a policy that some employers do provide or do require, but it's not required under the code, under the California Labor Code, whether non-exempt employees have to approve their own time cards. That is a policy that we do recommend, that they authorize and approve their time cards, but it always depends on the situation and how many employees you have and what pay role program that you utilize. So that is a possibility, but it's not necessarily required. And thank you for your comments and your compliments on these questions. Thank you. Let's see. Do we have time for another question, Brittany?
Yeah, if you see any, there's a couple questions about CLE. This is not a CLE webinar, so we do not have a CLE code.
Are meal break tracking for all employees who work exempt and non-exempt? No, meal break tracking is really only for non-exempt employees. Exempt employees can determine when they are taking their lunches or not. There's a lot of questions involving sales and bonus plans, and that is very specific to the type, that industry. So it really does depend on the circumstances of what types of bonuses and what commissions those sales associates could earn. So that's a very specific question. I can't really answer that without knowing a little bit more about the facts. Does a PTO plan cover California paid sick leave? It should. A combined PTO plan would potentially be a vacation, a combined sick and vacation time. And if there's employees in California, your PTO plan should cover the minimum required under the California paid sick leave laws, which is 5 days at least. I think that's all the time we have. So if we'll try to set up another webinar in the near future, and we'll make sure that you're on our list and continue to feel free to ask any questions going forward via email. Thank you.